Good morning and welcome to today's webinar. Today's topic is Ohio Workers' Compensation, an employer's guide to claim adjudication and COVID-19. Before we get started, I'd like to take a moment to go over a few housekeeping items. My name is Paul Federico, and I am the webinar organizer for today. We want to make sure today's presentation is extremely valuable to you, so we ask that you submit all questions by clicking on the question button in the control panel and typing your question there. So without further ado, I'd like to introduce Chad. Chad Fine has been practicing law in the area of Ohio workers' compensation for over a decade. After earning a BA from John Carroll University, which is a great institution, I also went to John Carroll University, way to go, Chad, and a JD from Cleveland Marshall Law, another excellent institution, Chad was admitted to the practice of law in 2005. Chad worked in human resources, operations, and compliance with Steel Transport, Inc. from 2000 to 2006. During that time, he managed over 200 employees and numerous workers' compensation claims. From September 2016 until the present, Chad has been in-house counsel for MinuteMen, Inc., a great partner of GCP for many years, and its associated companies. He regularly provides advice on workers' compensation claims, management, and attends over 1,800 hearings per year in front of Industrial Commission of Ohio. Mr. Fine has appeared in front of every current Ohio Industrial Commission hearing officer and practiced in several Ohio courts of common pleas. Without further ado, I'd like to introduce you to Chad Fine.
Thank you, Paul, and good morning.
Morning.
As Paul indicated, my name is Chad Fine, and I am the in-house counsel for the MinuteMen companies. We're a human resources consulting and service provider and work with numerous larger self-insured employers and smaller employers throughout the state of Ohio, and some that span our borders as well. For the past 15 years or so, I've limited my practice to representing the interests of employers, largely in Ohio workers' compensation matters. And I love interacting with employers. This is actually a new experience for me, interacting with you through a webinar. And as I was indicating to the Cose and the Greater Cleveland Partnership people this morning before, I hope I don't bomb because I can't see you. But nevertheless, I do love interacting with you and the system. And today we're going to talk about COVID-19. We're going to talk about how the Ohio workers' compensation system deals with this illness, and it's new for all of us, including the law. And we're also going to talk about the basics of what supports a workers' compensation claim, because until we understand the basic framework of our system, it really is impossible to talk about how COVID-19 fits into that system. I'm sure you've all heard the expression that the only constants in life are death and taxes. I've learned throughout my practice that for employers, there's an additional constant, and that's workers' compensation. What are the costs? What affects those costs? How do I help my injured workers return to work, return to the workplace and stay productive? How do I keep my workplace safe? And that's what the system is truly all about. So we're going to talk about some of the framework of the system. We're going to talk about what a workers' compensation claim is, what an occupational disease is, and what an idiopathic injury is. Those three concepts are important to understanding how the system deals with COVID-19. If there are three things that I want you to take away from today's presentation, it is that in Ohio, we work in a no-fault system. And what that means is as long as an injured worker sustains their injuries in the normal course and scope of their employment, that's a covered injury. I've had hearing officers tell me in the past when I've tried to raise the defense that an injured worker caused their own injury because of their own negligence, that Mr. Fine, stupidity is not a defense to a workers' compensation claim. And so I want you to understand that. The burden of proof, I want you to know what the burden of proof is to support a workers' compensation claim, and that is a preponderance of the evidence, and that means just slightly more likely than not that an injury occurred in the course and scope of employment. and that having a claim allowed for COVID-19, it's not a scary thing. We can deal with that within our system, and we can mitigate this claims such as a COVID-19 claims impact on your workers' compensation rates. So very quickly, the Ohio Workers' Compensation System was created in 1912, and it provides medical coverage and benefits to Ohio employers for injuries that arise out of the course and scope of employment. It also shields employers from legal action brought by the worker, brought by the injured worker. In other words, an injured worker is unable to file a lawsuit against an employer individually for a workplace injury. They have to file a workers' compensation claim. The system presently consists of two agencies, the Bureau of Workers' Compensation, as you're all aware of, and the Industrial Commission, and that's the adjudicative branch that handles disputes, and that's the body that I tend to practice in front of most frequently. So these are the players that are involved in the system. As I indicated, the Bureau of Workers' Compensation, that's the state agency that manages claims. That is where an injured worker will file a claim first. They provide coverage, they collect premiums from you, they manage the state insurance fund. If you're a self-insured employer, you manage those things yourself. But the Bureau does that for all of the employers that are part of the state insurance fund. Then, as I indicated, there's the Industrial Commission. They settle disputes and adjudicate issues and disputes between employers and injured workers within the system. There's the employer, that's you most likely today, the injured worker, the managed care organization, they're private companies which have been certified by the Bureau to manage state-funded workers' compensation claims. They also, for the most part, decide what treatment is appropriate to be provided to an injured worker in a workers' compensation claim, and they will work with you. They are they don't represent you directly, though. They don't represent your interests as an employer. There's one thing I want you to understand from this slide is that when you work with your managed care organization, understand that they're really outsourced from the Bureau of Workers' Compensation. And so any evidence they collect from both sides, from both the employer and injured worker. They work for the Bureau, and they are a neutral party. The employer's representative would be a third-party administrator, for instance, or attorneys that would be retained by employers. We represent you, your interests. And so as far as MinuteMen is concerned, we actually operate a managed care organization called 188 Ohio Comp. Some of you may interact with that managed care organization, and we also have our own third-party administrator. And the third-party administrator works for you, represents your interests in an adversarial position, and makes sure that that claims are mitigated in your interests as much as possible. And then there's the claimant's representative. Many times that's an attorney on the other side, and obviously they represent the injured worker and have positions adverse to yours. So claim adjudication process. The Bureau, as we indicated, is the first level in state-funded cases. They determine whether a claim should be allowed, whether an additional condition should be allowed in a claim, what treatment should be approved, any disability that could be related to those conditions and treatment. There are no hearings held in front of the Bureau of Workers' Compensation. And if a party disagrees with their decision, they file an appeal. And those appeals are sent to and adjudicated in front of the Industrial Commission of Ohio. Which will lead to a district hearing. And sometimes this is referred to as the second level, because the Bureau makes the first determination, and then the second level would then be the district hearing in front of the Industrial Commission of Ohio. A hearing is held in front of a hearing officer who is just an attorney, is not a judge. Many times, the first time I see any of you will be at one of these hearings or just prior to one of these hearings, or I may speak to you on the phone a week or two ahead of one of these hearings to discuss your dispute. Most of your interaction would have been with your third-party administrator, your claims manager. And then when a dispute arises, those disputes get sent over to me, and then we get to talk. And the first question I'll always ask you is, have any of you been involved in a workers' compensation? Have you attended a hearing in front of the Industrial Commission in the past? Some of you will say, yep, I was here. Many of you will say, I have never dealt with one of these before. And I'll say, congratulations, you're very lucky. Unfortunately, we have to meet under these circumstances. And I'll explain to you that a district hearing officer is not a judge. These are very informal hearings. They're held in conference room type settings. There's no records. There's no court reporter. There's no formal rules of evidence. And you don't see the dramatics that you would tend to see in front of a court of common pleas in a trial court or something that you may have seen on television. These are informal type of hearings. And the injured worker gets to present reasons why their issue should be granted, and we present arguments against it. The contested, all parties have the right to present evidence at these hearings, and any party that disagrees with the determination of a district hearing officer files an appeal within 14 days of receiving it by mail, and it causes us to have a staff hearing. It gives birth to a staff hearing. Same thing, just like a district hearing. It's the third level determination. And the parties have a right, once again, to present evidence or new evidence that wasn't presented at the district hearing, and a determination is then made. I'm going to pause here just for one quick second, just to ask, because I know I'm putting a lot out there somewhat quickly. If there are any questions, or if there's any discussion, if anyone's ever had an experience in these types of hearings and would like to raise that now, and we can talk about it briefly.
Yeah, this is Allison from GCP. We don't have any questions coming in yet.
Very good. So, someone's unhappy with the determination of a staff hearing officer, and they request a third level hearing. It's the final determination. The hearing, it's discretionary. You file an appeal with the Industrial Commission asking for a third level hearing, and the only time one of those hearings are heard is if there was a mistake of law or mistake of fact in the staff hearing order. 97% of these hearings are never even heard. It's completely discretionary, and if one of those hearings are conducted, the losing party can file an appeal to the Court of Common Pleas. If one of those hearings are not granted, then the losing party from the staff hearing can file an appeal to the Court of Common Pleas and ask for a trial court. So your reward for successfully defending a claim at every administrative level is trial court. So that's how a claim is adjudicated. Let's talk about what is an injury. Generally, an injury includes any injury received in the course of and arising out of employment. An injury does not include a psychiatric condition unless that psychiatric condition is related directly to a physical condition already allowed in a claim, or the psychiatric condition results from a sexual assault that does not result in a physical injury. An injury does not include disability caused primarily by the natural deterioration of tissue or an organ. And an injury or disability will not be covered if the employee is participating voluntarily in a recreational or physical activity sponsored by the employer, provided the employer has the injured worker sign a release prior to the participating in such a activity. There are several circumstances that could preclude a workers' compensation claim for an injury. purposely self-inflicting an injury on oneself would not be covered. If an injury results from intoxication rather than the normal course and scope of employment, in other words, the injured worker was drinking or under the influence of a drug of some kind when they were injured, and that is the actual cause of the injury, then those injuries are not covered. Some of you may have questions at some point in time how Ohio deals with legalized medical marijuana use, and we can talk about that at some other time. But just so you know, that intoxication, even for using a legal substance, if that is the cause of a workers' compensation of an injury, that will not be covered by workers' compensation. Horseplay in fighting, doing something that is completely outside the course and scope of employment, for instance. If an injury occurs when someone is using a conveyor belt and simply moving a box off the conveyor belt, that would be covered. But if the injury occurs because the injured worker thought it would be fun to pretend to be surfing while riding on the conveyor belt, that would not be covered. And there are travel-related injuries as well. If an injured worker is injured while traveling in the course and scope of their employment, that would be covered. There's something called the going and coming rule that we can talk about at another time, but that basically indicates that if an injury occurs before a worker reports to work, before they're on the clock while they're traveling to their place of employment, that would not be covered. But if they first report to work and then are traveling out to a service call and are injured while traveling to that service call after they have already presented to work for that day, that would be covered. And that could have impact with COVID-19 for a home health care aide, for instance, who may have contracted the disease after traveling to someone's home. So that's something I do want to keep for you to keep in mind. As I indicated before, purely psychological injuries are not covered unless they result from a physical injury that gave rise to the claim. Generally, if the injured worker has a pre-existing condition, and that pre-existing condition is what we call substantially aggravated by the mechanism of injury that gave rise to the claim, by the trauma that gave rise to the claim, then the claim could be allowed for substantial aggravation of that pre-existing condition. That's usually determined with medical evidence showing that the condition existed prior to the date of injury. And then there's objective evidence that the injured worker would have to prove to show that it was made worse by the trauma that gave rise to the claim. Usually you see this in degenerative conditions or with arthritis. If a person has a condition, for instance, an arthritic knee, and then they fall on that knee, and then it becomes worse as a result of that direct impact on their kneecap, and they can show objectively that the findings were minor, and they are now severe, moderate to severe after the injury, a short time after the injury as a result of the trauma, that now we have objective evidence to prove that there is a substantial aggravation of a pre-existing condition. That can also be allowed and covered as part of a workers' compensation claim. I'm going to slow down a little bit as we start to talk about occupational diseases, because the occupational disease is what is going to form the basis of a COVID-19 claim. An occupational disease is defined under the Ohio Workers' Compensation Act as a disease contracted in the course and scope of employment where the nature of employment puts the employee at a risk of contracting the disease to a greater degree and in a different manner than what would be true of a member of the general public. In other words, someone who is performing a job where they are exposed to the disease in a substantially greater dosage than you or I, who are doing just going to the store or working or doing anything else at home. You would tend to see these more often with home health care workers or people in the medical field. I'm going to skip past that one moment. And we're going to go right to idiopathic injuries. So idiopathic injuries and sustaining COVID-19 in the course and scope of employment as an occupational disease work hand in hand. In order for a workplace injury to be compensable, it must arise out of and in the course and scope of employment. We discussed that about 10 minutes ago. An injury arises out of employment where there is some causal connection between the conditions under which the employee worked and the resulting injury. So in a very simple example, a truck driver who is exiting their truck, and let's say they have a high ladder or set of steps to climb down, and as they do so, they hyperextend their leg, and it causes an injury. That's something that's very specific to their employment and could be covered. Whereas an individual who's walking down a normal flight of steps and their knee just sort of gives out. They don't trip, they don't slip, they just knee just sort of gives out. And then they sustain an injury. That's not related to employment. That would be an idiopathic injury. Everybody experiences that the same, and regardless of the employment, the injury would have occurred. An idiopathic injury is generally described as one that arises from circumstances peculiar to the individual employee rather than a risk caused by the employment. It arises spontaneously. It arises from an obscure or unknown cause or from a personal condition. Could happen anywhere. It's not related to employment. An injury may be compensable if the employment significantly contributes to the injury by placing the employee in a position where the risk of dangerous effects of experiencing the incident are increased. So these are very fact-specific cases. Nevertheless, it's important to understand what an idiopathic injury is. So this is a case that I just put up here because it's one that's cited quite regularly these days, and just to pat myself on the back, it's a case that I was involved in where I represented Horizon Health Services, and the injured worker lost consciousness while driving in the course of their employment because they had low blood sugar. And when they lost consciousness, they were at a stoplight and the car just sort of rolled through the stoplight. It hit a utility pole and they sustained some injuries. And we were able to prove that the cause of those injuries was the diabetic condition. It wasn't unique to this injured worker's employment, and they could have passed out for any reason. And the claim was denied. So now we'll start talking more specifically about COVID-19. How can an employee who sustains this condition establish that this is that a claim is compensable based on COVID-19? And it goes back to the occupational disease analysis. It is not easy for a claimant to sustain their burden. And remember, the burden is a preponderance of the evidence, just slightly more likely than not, that COVID-19 was sustained in the course of employment and arose out of employment. In order for an employee who sustains COVID-19 to sustain their burden, they must satisfy a three-part test. 1, was the disease contracted in the course and scope of their employment? Was there an incident And I'll use the example of a home health care aide or a nursing home employee who is treating a patient who tested positive for COVID-19. And if there is a specific incident, for instance, that this positive COVID-19 patient sneezed, coughed, maybe some other bodily fluid splattered onto the employee, we have an incident where we can point to and say that this is the incident where COVID-19 was contracted. The disease has to be peculiar to the claimant's employment by its causes and characteristics. In other words, but for the employment, the injured worker or the employee who sustained COVID-19 would not have been in this position, would not have been interacting with someone who so closely who had tested positive for COVID-19. And that the employment creates a greater risk of the disease, and to a greater degree and in a different manner than the public in general would experience. And we can see that quite easily with a healthcare worker who is working with someone who had tested positive for COVID-19. We can see that for a home healthcare aide. We can see that for a first responder, a police officer, a paramedic, someone in the medical profession who is forced into these situations. Many employers will tell me, and we have numerous cases that have been filed throughout the state for this condition right now, that, well, my employee was wearing personal protective equipment. They were wearing masks and gloves and other protective equipment to protect them from sustaining COVID-19. So this should mitigate or eliminate the factor that that the employment placed them in a position of risk greater than that to the general public. And that might be a factor that we'll present for litigation. The cases are still a little bit too early. We haven't had an opportunity to fully adjudicate these matters yet, and that's certainly a factor that I would present on my client's behalf. It is my impression, though, that that fact alone will not carry the day and will not allow us to be victorious on its own, because we all know, and we've been all told by medical professionals, that simply wearing a mask or wearing gloves is not going to stop an individual from sustaining COVID-19. It's going to lessen the chances of really transmitting it to somebody else if you have it, but it may not protect the person from sustaining it themselves. But of course, the science continues to change on that as well. So for the first element, the claimant has to prove that they were exposed to the virus. They received a medical diagnosis of COVID-19 by a doctor who causally relates the diagnosis to the employment. Many doctors will diagnose and causally relate the diagnosis to the employment without a positive COVID-19 test, especially over the last 3 or 4 months, because we haven't had access to these tests until most recently. Now, it is my understanding that everyone in the state of Ohio has access to these tests almost by request and appointment, but up until now, that hasn't been the case, and many doctors simply didn't use a test to diagnose the condition. If a person had flu-like symptoms but tested negative for the flu, for instance, they might diagnose COVID-19. That is a diagnosis, and it will be supportive of a workers' compensation claim as far as the requirement to have a diagnosis. And then if a doctor causally relates the condition to the course and scope of employment, the injured worker will have satisfied that requirement. And when a doctor causally relates the condition, they do so within a, what's called, and this is a legal term of art, reasonable degree of medical certainty or probability. It seems somewhat ambiguous, but what it really means is that it's, once again, just likely, within a medical probability, slightly more likely than not, just like the preponderance of the evidence standard. A doctor can say, yeah, the injured worker was working in an environment where they were exposed to COVID-19. We're diagnosing them with COVID-19, so I can say within a reasonable degree of medical probability that they sustained COVID-19 in the course and scope of their employment.
Hey, Chad?
And then, yes.
Couple quick questions here that might fit right now.
Sure.
So if a positive test occurred in a factory, would that qualify as contracted at work?
No, not on its own, because remember, just having a positive test is not enough to support a workers' compensation claim. You still need a medical expert, a doctor, to indicate that it was sustained and that there's a causal relationship. And I know that may not directly answer your question, because as an employer, you might be saying, well, they can go out and get any doctor to say that they sustained this disease in the course of working for me. Why should that be enough to sustain a workers' compensation claim? I'm going to throw a little bit more frustration out there and say they might find a chiropractor to say that too. That's okay. We can still defend against those things. You start getting into litigation, and that's when we would talk to you, evaluate the facts. We would examine all their medical records, do a thorough investigation of where they might have interacted outside of the workplace. Maybe a family member of theirs has sustained COVID-19. Maybe a family member of theirs works in a nursing home and brought COVID-19 home. And we would do a thorough fact discovery to establish those facts. We may also obtain a medical examination from an expert of our own. And then we would take all of these facts in front of the Industrial Commission and have hearings, as we talked about earlier, to fully adjudicate this matter. Remember, it has to be slightly more likely than not. But in my opinion, just having a diagnosis of COVID-19, just because you work in a factory alone, is not going to make it slightly more likely or not that this condition was sustained in the course and scope of employment. Now, add to that the fact that the injured worker might have been working in a factory with 3 other people who also tested positive, and that's going to change the fact pattern somewhat. Now, maybe it is more likely that this injured worker sustained the disease from them. So it is very fact intensive and very fact specific. But just having a positive diagnosis as a result of a test that the employer provides is not going to be enough to sustain a workers' compensation claim on its own.
One other question, a little more general. How long does a typical workers' comp appeal take, and has the COVID-19 affected the timing of the process?
So there are specific timelines that the Bureau works within and the Industrial Commission work within to set hearings. It's 21 days from the date an order is appealed that it has to be referred to the Industrial Commission and set for hearing. And then there are statutory timelines that the Industrial Commission also are required to work within to set hearings. However, the discovery process and the period of time necessary to collect evidence for both the injured worker to support their claim and also the defense to defend against their claim might delay the process. So before a hearing is heard, many times we as the employer will request 1 or 2 or maybe 3 continuances of a hearing to push them out a little bit in order to provide us our opportunity to collect medical records, to obtain expert medical reports, and to conduct the necessary discovery so that we can fully adjudicate this claim in the fairest way possible. The Industrial Commission and the Bureau really both do tend to want to process claims as quickly as possible, because most claims, the vast majority of claims are actually valid claims, and they want the injured worker to be able to collect benefits that they're entitled to. But the ones that get set for adjudication, they do tend to take a little bit longer, just so we can have an opportunity. Some of you might laugh, or some of you may not. I tend to think the best job I've ever done as an attorney on a claim was postpone the adjudication of an initial allowance hearing 5 years. And I did so because I was requesting medical records from a medical provider that was unwilling to provide those records to me. And it was a state fund claim. And by the time the claim was eventually adjudicated, it was already outside the experience of the employer. So these things could take time. It requires all sides to cooperate, and the employer is entitled to medical records and discovery. And without that information, it could take longer to process appeals. So, novel coronavirus, other occupational disease claims. Claimants that are healthcare workers are more likely to be able to establish their claims than employees of other occupations, simply because of the level of exposure we know that healthcare workers and first responders tend to have with COVID-19 positive patients. But the other thing for you to know is that communicable diseases like COVID-19, for instance, influenza, do not typically rise to the level of a workers' compensation claim, simply because it's difficult to establish that an injured worker was more likely than not to sustain those diseases in the course and scope of their employment than if they were just out in the general public. And it is my opinion that over time, it'll be much less likely for injured workers to establish a claim for COVID-19, simply because we are all circulating now. More and more, the economy in Ohio and other states is opening up. And because of that, we are more and more likely to be exposed to COVID-19 anywhere, not just in our workplace. During the stay-at-home order, when 90% of us, or maybe some of you would say 70% of us, I'm not sure what the numbers are, many of us were staying at home and not leaving the house at all for any reason. Those people that were leaving the house, people that were allowed to work and sustain COVID-19 would have been more likely than not to, would be more likely to be able to sustain a workers' compensation claim for COVID-19, simply because there was no other place for them to be exposed to the disease than at work. Quarantine alone for COVID-19 will not be enough to sustain a claim. So many employers will say, well, I had a person who wasn't feeling well. The doctor didn't technically diagnose them with COVID-19, but said, stay home for 14 days. Can they have a workers' compensation claim? No. Remember, you must have a diagnosis, and it must be causally related to work. And if a person is at home or was at home under some sort of a quarantine recommendation for possible COVID-19 exposure, there were other avenues for them to collect compensation. The Ohio Department of Job and Family Services, I believe, has programs for them as well. I did not mean to do that. Okay. Working from home. Many employees worked and continue to work from home. I'm still working from home. Many of us still work from home. And the injuries that occur in the course and scope of employment while working at home may also give rise to a workers' compensation claim. It's something for you to keep in mind. Just because a person is working at home does not mean that they are less likely to file a workers' compensation claim. It may not be for COVID-19, but it might be because they were printing something out for work at the printer, which happens to be at the other end of the kitchen table. And as they stood up, they stepped on a Lego that their child left on the floor, tripped, fell, and sprained their ankle. That may now be a workers' compensation claim. So it's something to keep in mind. You still must have an incident, a diagnosis, a doctor relating that to the course and scope of employment. It's frustrating. I understand that. But it's something that I anticipate we're going to see a little bit more of, simply just because so many people have been working from home. As long as they were performing their duties and weren't involved in horseplay, it would be covered. Of course, the question you're all asking right now is, how will I know? There were no witnesses. It becomes a difficult evidentiary case for us to make against the claim. Remember, preponderance of the evidence, slightly more likely than not. I'm going to pause here, just so you know, the statute limitations for certain administrative and court actions have been told during the state of emergency, meaning an injured worker has longer to file claims. That's from your perspective, that's all you really probably need to take from this slide. That an injured worker has more time to file a claim. The normal statute is 2 years for occupational diseases from the date of diagnosis and causal relation to the course and scope of employment. They're going to have a longer period of time based upon the state of emergency, which right now technically expires at the end of July and July 30th, unless the governor extends it or ends it sooner. And I don't anticipate the governor is going to end the state of emergency sooner than July 30th. So if it ends on July 30th and a claim was filed or injured worker is diagnosed and receives the causal relations statement from a doctor on July 15th, 15 days before the end of the statute limit, before the state of emergency expires, they can add those 15 additional days to the end of the normal 2-year period statute of limitations. If those things happen on July 1st, they can add 29 days to the end of the 2-year statute of limitation period. It's 2 years for filing an occupational disease, 1 year for a physical injury. Are there any questions about anything we've discussed so far?
Chad, you've been doing an awesome job of answering questions before I had a chance to ask you them, so really good job. Also, one comment about someone stepping on a Lego. Thankfully, they did not break their ankle in their case, but keep the good examples coming. Thank you.
Oh, wonderful, good. Was that actually a question?
No questions. They're very good. You got them all covered.
Good. Okay, so and I'm not going to go through the particulars of tolling of the statute of limitations with you right now. It's in the presentation, and you can read those things, and we can talk about them as well at another time. I've already gone over my specified time limit by about 15 minutes. So what I'd like to do is just cover a few different things. The Industrial Commission, going back to one of your questions about 15 minutes ago, you were asking about appeals and how long it takes to go through the appeal process. The Industrial Commission has converted all hearings right now to telephone hearings, telephonic hearings. As many of you may be aware, you may have attended these hearings in the past, or maybe you've been fortunate enough not to have a workers' compensation claim that's been in dispute and you did not have the pleasure of attending these hearings. I happen to love them, by the way, but many of you, you'd rather do without them. We tend to do them in person, and there are 12 offices throughout the state. In Cleveland, we have 11 rooms in our office, and there are 12 offices throughout the state. And they typically are held 4 hearings every hour throughout the day, which is why I have the pleasure of attending about 1,800 hearings a year, because I'm attending 3 to 4 hearings every hour all day long in front of the Industrial Commission. These hearings have been converted to telephone hearings. And if any of you, you can remember from years ago when we had party lines before the age of the internet to dial into, that's what a telephone hearing is. It's a party line. And everyone gets to call into this party line and hear everybody else, and they're very cumbersome and very difficult to adjudicate. But the Industrial Commission is doing its best to handle all of the issues: permanent total disability, permanent partial disability, allowance, initial allowance, additional allowance, wage loss. Every issue right now, they're doing their best to handle telephonically. It takes longer. They only schedule 2 hearings per hour now, and it's as you would imagine, through the telephonic system, when you're not seeing people in person, when you're it's difficult to present documentary evidence, video evidence. It's tough to hear people. People have bad connections. Many people simply don't know how to use this telephone, and so it becomes difficult to adjudicate. It actually takes longer. We are experiencing more continuances than we ever have before, simply because people can't figure out how to dial into a hearing, and it's difficult to present evidence. Many people have said, well, why don't they just do Zoom meetings just like we're doing right now? And that has been discussed, but the reason the Industrial Commission has been hesitant to conduct video hearings is mainly because you have really the same problems you do at telephonic hearings. People have bad internet connections, just like bad telephone connections. People have difficulty using technology. Many parties are not represented by attorneys and would be forced to buy computers to participate. And so the preference always is for an in-person adjudication, and the telephone is considered a good next, less intrusive means that everyone has access to be able to participate in lieu of telephonic hearings. But we're hopeful as soon as a vaccine is available or the danger of infection has been reduced significantly to be able to go back to do these things in person and adjudicate hearings more efficiently and on quicker timelines. I'm going to put up for you right now my contact information. This is a good time to ask any questions that you feel I did not cover. And if you don't feel comfortable doing so online right now and you still would like to talk with me, here's my contact information. And I'm available whenever I'm not in hearings, but if you call me and leave me a message or email me, I'll be sure to get back to you within 24 hours, usually sooner. And we can talk about any issues you have. If you're one of our clients, that usually means you have a claim with me and you're not happy about having a claim, but hopefully I can make it less painful for you. And if you don't have a claim, hopefully I can help you navigate the system so you feel more comfortable with it.
Chad, a lot of great comments and thank yous. I think you'll be getting some calls based on that information up there. No more new questions, so I think we're good to end the session. Fantastic job, great examples, great everything. Thank you so much for doing this today. Thanks to you and to MinuteMen for being such a great partner of Cose and the Greater Cleveland Partnership.
Thank you. I enjoyed my time, and hopefully we can do it again.
Outstanding.
All right, if there are no further questions, that concludes today's webinar. Thank you, Chad Fine, for joining us today, and thank you to all of our attendees. Have a great day, everyone.
Thank you.